Good afternoon. Warm greetings to everyone. Carefully calibrated at 31.6 degrees centigrade. And it's not steamy because it's only 50% unusually for us of relative humidity. I hope you've all had a nice lunch break or breakfast break, as the case may be. So welcome to session 3. The new Singapore International Commercial Court rules. I will start with a few introductory remarks and then I will hand over to Yuna to do some of the harder work on the rules itself. So let me start by saying, usually lectures on civil procedure are a surefire way to send all your attendees to sleep. But we hope we have 2 silver bullets with us that will keep you awake. First, as you have heard, we have a stellar lineup of 7 speakers, all of whom I think need no introduction. They're very well established in their own fields and they're all stellar legal luminaries, whether on the bench or in the world of commercial dispute resolution. Second, we hope that the novel approaches that we will outline, taken by a court, which actually sounds a bit like an oxymoron, in our new rules will be something that is revolutionary and yet familiar to people who do international arbitration or who appear in international commercial courts. We launched the SICC in January 2015 with the existing Rule 110 grafted onto our existing civil procedure rules. And we also had SICC practice directions to help on the conduct of the SICC proceedings. But over the 6 years, there have been quite a lot of internal discussions on our case management, our procedures, and our experience in the cases that were coming up for hearing. And one of the queries that was actually raised quite strongly came from our civil law brethren who said, why is there so much repetition in the affidavits? We read the same story again and again and again. And he says, this is terrible. There's so much unnecessary duplication. And this and other conversations led us to sit back and think, are we really doing things the best way we can? And so we looked more and more into the various options open to us. And then we had our Civil Justice Commission, which looked into basically simplifying our rules. And it was then that we realized that we actually need some standalone rules for the SICC. So we put together a committee of 15 judges, which included civil law judge, retired judges who were very active arbitrators and who had good working knowledge of international arbitration, as well as some very hard-working members of our registry, who then proceeded to comb through all the various procedural rules for the courts around the world, as well as look into many of the arbitral rules from the various institutions. And so work commenced on drafting something like a complete set of rules for the SICC. And we set about doing this with one guideline, and that was to incorporate the best international practices from international commercial litigation as well as international arbitration. In 2019, we had very targeted consultations with stakeholders, local and foreign lawyers and in-house counsel. There was very valuable feedback given to us, and we studied it, considered it, and incorporated them wherever possible. So the new SICC rules retain many key features of the existing SICC procedure, but we introduced some very new and novel changes which we hope will enhance the SICC and make it more attractive for potential users. So, for example, the jurisdictional requirements of the SICC remain unchanged, but the existing jurisdictional rules, such as definitions of international, commercial, place of business, jurisdiction agreement, etc., have been reorganized and simplified so as to enhance clarity and brevity. The new rules also introduce certain presumptions which we think will help parties, and these flexible features are very much part of the SICC's existing procedure as they stand, and we added on portions that we thought were useful. So by these new rules, and we think there will be even more flexibility introduced. So let me just highlight a few key points. The commencement of a case in the SICC has now been simplified, and introduction is by a single mode of commencement of proceedings. So there'll be only one mode to commence proceedings. Thereafter, it may move on to 3 adjudication tracks: the pleadings track, the statements track, or the memorial track. Which track will be used happens at a case management conference, which is held after the defendant responds. The parties then can agree, or failing agreement, the court will decide, after hearing the parties, which of the 3 adjudication tracks the case will proceed along. Notably, the court may also modify the default procedures applicable to each track, so as to tailor the procedures to an individual case in such a manner and to such extent as the court considers appropriate. Bernard and Nicholas will elaborate on this later. Most importantly, as currently practiced, there will continue to be robust case management, which will start at a very early stage of proceedings to streamline the dispute for an orderly resolution, prevent dilatory practices and delays, and to control the costs. This has been and still is a major criticism against international arbitration. As we see in the literature, many arbitrators are reluctant to deal firmly with dilatory tactics, and they are concerned that their awards may be set aside for a lack of a fair hearing. And in the literature, this is called due process paranoia. As with the present Order 110 Rule 3, the new SICC rules will expressly provide for very wide powers of the court to do what is necessary or desirable for the just, expeditious, and economical disposal of any proceedings. One example is that there will be no expert evidence unless the court approves. The court is also empowered to make such order as it considers just and appropriate in the circumstances, notwithstanding any provisions in the rules. And in doing so, the court will be guided by the 4 general principles which Yuna will take us through. The intention is for the process under the new SICC rules to remain very much judge-led. From our experience and users' feedback, this feature has proven to be invaluable, and this will not change under the new rules. So, before I hand over the session to Yuna, who will give you a brief overview of the new SICC rules, it will then be followed by discussion by Justice Eder or Bernard and Nicholas to lead a discussion on the case management aspects of the new SICC rules, including the single mode of commencement of proceedings and the 3 adjudication tracks that I referred to earlier. Lee Ming and Toby will then focus on the presentation of factual evidence under the new SICC rules, and in so doing, will be touching on disclosure of documents and trial management. Finally, Cameron and Cavinder will be discussing the use and presentation of expert evidence in the SICC, and will also share their user perspectives of the new SICC rules. We will then round up the session by opening the floor to questions from the audience. So Yuna, I hand this over to you now for this introduction to the new rules. Thank you.
Thank you very much, Judge, and a very warm welcome to everyone. I will start off my broad overview of the new SICC rules with the general principles that Judge mentioned earlier. These general principles you see here are expressly set out in the new SICC rules. They really are what the new rules hope to achieve, and they're intended to guide the interpretation of the provisions under the new rules. As Justice Loh mentioned, there is a very broad discretion given to judges and the courts under the new rules to really tailor the procedure to suit the dispute at hand. And this discretion is to be exercised with reference to these general principles. Parties are also required to conduct their cases in a manner consistent with these principles. As Justice Loh mentioned, the jurisdiction of the SICC remains unchanged under the new SICC rules. The SICC continues to hear generally cases which are international and commercial in nature, where the original parties to the proceedings have submitted to the SICC's jurisdiction under a written jurisdiction agreement, and where no party in the proceeding is seeking any prerogative release, that is, judicial review type release. The SICC continues to hear cases that are transferred from the General Division of the High Court to the SICC, as well as proceedings under the International Arbitration Act, such as applications to set aside arbitral awards, applications for the enforcement of awards, and to resist such enforcement. Importantly, the SICC retains its compulsory jurisdiction to join new parties to the proceedings. This is something that the SICC can do even now, and is really what sets the SICC apart from international arbitration. As we know, in order to join new parties to existing arbitration proceedings, one generally requires the agreement of all parties, including the new parties sought to be joined. The SICC, however, being a court, has the jurisdiction to compulsorily join new parties to the proceedings, so long as it is appropriate to do so, for example, where there are claims for indemnity or contribution against the new party. The claims against the new party in and of themselves need not be international and commercial, so long as the proceedings as a whole retain their international and commercial nature. And the new parties need not have submitted to the SICC's jurisdiction by way of a jurisdiction agreement unless the new party sought to be joined is a state or sovereign of the state. Again, as Justice Loh mentioned in his opening earlier, the jurisdictional rules are simplified under the new SICC rules. The definition of international, the definition of commercial are examples. Under the new rules, a matter is considered international so long as at least one of the parties has its place of business outside Singapore, or the subject matter of the proceedings is most closely connected to a place outside Singapore, or a substantial part of the obligations is to be performed in a place outside Singapore. And a matter is considered commercial so long as it arises from a relationship of a commercial nature. In addition, the new SICC rules introduces a presumption that an action is international and commercial so long as there is a written jurisdiction agreement among the parties. This is an evidential presumption, it is a rebuttable one, and it really is to simplify the process of parties bringing a case to the SICC. This is not intended to affect the court's power to consider its jurisdiction and exercise of jurisdiction. One more change to highlight is that there is no longer any requirement for all parties to consent before an application may be brought to transfer a case from the General Division of the High Court to the SICC. Presently, such applications may be brought only with the consent of all parties, but contested applications are allowed under the new SICC rules. I should highlight, though, that this only relates to transfers from the General Division of the High Court to the SICC. It doesn't apply to transfers from the SICC to the General Division of the High Court, In those cases, the consent of all parties is still required before a transfer may be effected. Moving on to legal representation. The legal representation rules under the new SICC rules also remain unchanged. Apart from being represented by advocates and solicitors called to the Singapore Bar, parties in SICC proceedings may also be represented by foreign lawyers registered with the SICC in certain circumstances, such as in offshore cases with no substantial connection to Singapore, and where the court has granted leave for questions of foreign law to be determined on the basis of submissions instead of proof. In those cases, parties may be represented by registered foreign lawyers to make such submissions on foreign law. One of the biggest changes introduced under the new SICC rules is the single mode of commencement of proceedings. Again, this is to simplify the process of parties bringing a case to the SICC. Instead of having to decide pre-commencement which mode of commencement to commence a case under, the parties would simply commence proceedings under the new SICC rules by way of an originating application and accompany that originating application by a concise summary of their claims. Thereafter, there will be a process where the defendant would then file a concise summary of their defense, and the parties would then attend before the court at a case management conference, where the court would hear from parties, would consult with the parties before deciding on the most appropriate adjudication track to be applied to the dispute at hand. As Judge mentioned earlier, there are 3 default tracks provided for under the new SICC rules. The pleadings track, which is akin to the current writ action and generally culminates in a trial of the matter. The statements track, which is generally the originating summons procedure currently and generally culminates in a hearing on submissions. And the memorials track, where parties would file memorials setting out both facts and law and accompany those memorials with evidence to be relied on, such as factual witness statements, expert witness statements, if any, documents being relied on, etc. I should also highlight at this stage one further change in relation to the pleadings track. Under the new SICC rules, pleadings are now required to be verified by a statement of truth. So the party who's pleading, that is, would have to sign off and confirm that the statements of fact in that pleading are true to that party's honest belief. This, of course, excludes assertions of law. And this would also extend to matters which are outside that party's personal knowledge, but based on information and documents available to the party. The intention behind the statement of truth requirement is really to give litigants pause for thought, to make them carefully consider the statements of truth to be included in the pleadings on which allegations will be based. The case management conference really lies at the heart of SICC proceedings. It is a judge-led case management conference, and as Justice Loh mentioned, it comes at a very early stage of the proceedings. Justice Eder and Mr. Lingard will take us into more detail on case management conferences, and I believe they will be focusing on the very important first case management conference where the court actually decides on the adjudication track to be applied. So it suffices for me here only to point out that the provisions of the new SICC rules are really framed in an ADR-friendly manner. That is, alternative dispute resolution friendly. Parties are expressly required under the new SICC rules to consider the possibility of ADR and to update the court at the next case management conference. The court is also expressly empowered to make directions at case management conferences to facilitate ADR. And the parties' conduct in undertaking ADR or refusing to undertake ADR may be a factor that the court takes into consideration in determining costs at the end of the day. The disclosure of documents regime under the new SICC rules is a flexible regime. By default, there is no general discovery process. Instead, the parties would produce documents that they intend to rely on. Then, there will be a request to produce procedure by which the other party has the opportunity to make requests for specific categories of documents. The party being requested will then either agree to produce the documents or object to the production, in which case the court will rule on the objections. This request to produce procedure is akin to that found under the IBA rules on taking of evidence in international arbitration. The court may, however, in appropriate cases, order general discovery to be conducted. For example, in cases of fraud or cases where there is a very large asymmetry of information and documents between the parties. And in appropriate cases, the court may also order that disclosure of documents be dispensed with altogether. Evidence under the new SICC rules is now to be adduced by way of witness statements by default. This is a change from the present position where formal affidavits are actually required. The intention is really to save the time and cost incumbent on the formalities of deposing affidavits, and this is something that is consistent with international arbitration practice. There are, however, some specified exceptions. For example, where sworn evidence is required by law, where evidence is being adduced in support of applications for injunctions, search orders, and order to enter into another person's property or land, or where the evidence is being adduced in support of an application for an order against the person for contempt of court. In these exceptions, affidavits will be required, but in all other circumstances, by default, witness statements will be used. Under the new SICC rules, parties will require the leave of court in order to adduce any expert evidence. And in granting or considering the grant of such leave, the court will have regard to two questions. First, whether the evidence contributes materially to the determination of any issue. And second, whether the issue may be resolved by other means, such as an agreed statement of facts or submissions on mutually agreed materials. I turn now to touch briefly on the conduct of trials and hearings under the new SICC rules. For trial under the new SICC rules, the default is a requirement of a single trial bundle. Under the present practice, there are usually multiple bundles used at trial. There will be an agreed bundle of documents. There will be usually a bundle of affidavits of evidence in chief, a bundle of pleadings, and oftentimes a plaintiff's bundle of documents and a defendant's bundle of documents where parties cannot agree to those documents being contained in the agreed bundle. Sometimes counsel also produces a core bundle or a cross-examination bundle for use at trial. What this means is that a single trial could have multiple bundles, and a single document could actually appear multiple times across the bundles. For example, a document could be found in exhibits in more than one affidavit. It will also be found in one of the bundles of documents, and sometimes it could be found also in the core bundle or cross-examination bundle. The single trial bundle requirement is really to address this issue of proliferation of trial bundles and duplication of documents. In appropriate cases, of course, such as where there are voluminous documents, the court has the power to order parties to produce a core bundle in addition to this trial bundle. But in most cases, the default is intended to be a single trial bundle. In the conduct of hearings and trials, the court, under the new SICC rules, may also dispense with an oral hearing and make a decision on the documents filed with the parties' consent. This is another feature which demonstrates the flexibility under SICC procedures. For appeals, appeal procedures are broadly categorized into two categories: appeals in respect of decisions made on applications, and appeals in respect of decisions made after a trial or hearing on the merits. For appeals and applications, it is really a quicker process, so parties are to file and exchange a single set of written submissions 4 weeks before the Court of Appeal sitting in which the appeal will be heard. For appeals after trial or merits hearing, the procedure follows something that is similar to the existing procedure. So parties will have 8 weeks to file their appellant's case, 4 weeks thereafter for respondent's case, and 2 weeks thereafter for the appellant's reply, if any. However, there will be no skeletal submissions unless the Court of Appeal orders otherwise. As with the first instance court, the Court of Appeal may also dispense with the oral hearing of an SICC appeal with all the parties' consent. And parties continue under the new SICC rules to be able to waive or restrict or limit their right to appeal by agreement. Finally, I come to costs. As is presently the case, there will be no taxation under the new SICC rules. The quorum who heard the substantive matter will generally be the quorum who will fix or assess costs of the matter at the end of the day. The starting point under the new SICC rules is the quantum of the cost award will generally reflect the cost incurred, but this is subject to the principles of proportionality and reasonableness. The new SICC rules sets out a list of non-exhaustive circumstances that the court may have regard to in fixing costs and considering proportionality. For example, one of the factors listed is any agreement that the parties may have on costs, including the basis for determining costs or the mechanism for determining costs. All these are matters that the court will have consideration to and will have regard to in fixing costs. I come now to the end of my broad overview of the new SICC rules. I will now hand over to my fellow panelists who will go into more detail on some of these features. Thank you.
Thank you, Ms. Yuna Khng. Next, may we please invite Justice Sir Bernard Eder, please.
I say good morning. I send you warm greetings from London, and thank you all for inviting me to speak this morning. First of all, I would like to thank Justice Loh and Yuna, and indeed the whole team at the Registry, for the huge amount of work that they have done over the past few years in driving this project forward. It is an important and exciting project, and the purpose is really to create a modern commercial litigation system, which will be perhaps the template for around the world. And Yuna and the team at the Registry, as Justice Loh has said, have sought to draw together the best practice from both litigation and arbitration, international arbitration, from around the world. And I have to say, it's been a real pleasure being part of this project and helping to drive it forward. I'm going to focus right at the beginning with the commencement of the new of litigation under the new rules, and with Mr. Nicholas Lingard, he will speak as well in a moment. And to make things a little more exciting, we've arranged a poll for you in a few minutes, which we will invite you to. I will invite you to participate in. But just rowing back for a moment. We all know modern court litigation to date in most common law jurisdictions, including Singapore, of course, and England, follow a standard path consisting of 5 main stages. And they are: first, you issue your writ, followed by pleadings. Second, there is disclosure of documents. Third, there is an exchange of affidavits of evidence in chief or witness statements in England, and then supplementals. Fourth, there is sometimes exchange of experts' reports. And fifth, you then have a trial. This will radically change under the new SIC rules. The new rules will be active judge-led case management with a view to the greatest possible flexibility in the preparation of the case for trial. And in particular, as Justice Loh has said and Yuna has said as well, the new SIC rules introduce separate adjudication tracks decided by the judge at an early case management conference, almost right at the beginning of the case, which will map out the whole case going forward. As previously said, there are 3 main adjudication tracks: pleadings, statements, and memorials. Starting first with pleadings, that is going to be very similar to what is existing litigation in the court at the moment. It will follow the traditional 5 stages of court litigation, but with an increasing emphasis on robust judge-led case management. Turning then to the statements adjudication track, that again is broadly similar, as Una said, to the existing originating summons type procedure, which might be used, for example, if the only issue in a case is the proper construction of a document and there would be no evidence. I suspect perhaps that this will be not frequently used in the SICC, but it is an obvious and important option. The biggest change, of course, is the introduction of the possible adjudication track for memorials. This is completely new. The use of memorials is an import from civil law jurisdiction and is now widespread in international arbitration. It is radically different from pleadings because in addition to setting out the facts, legal grounds and relief sought, each party is required to serve at the same time as its memorial, either a claim or defence, copies of all its witness statements, experts' reports, if any, and documents supporting that party's case. Needless to say, the decision to proceed by way of pleadings or memorials will have a radical effect on the process. So what will happen now, and you will see a slide up on the screen, is that under the new rules there will be a single mode of commencement of proceedings by way of an originating application containing the claimant's statement, which is then followed very quickly by the defendant's statement. Both statements are intended to be no more than a concise summary of the parties' respective cases. This mirrors the practice in, for example, ICC arbitration, where the claimant serves a request for arbitration, the respondent then serves an answer. The purpose is to provide a broad overview of the case to enable the court at the first case management conference to decide whether to proceed by way of pleadings or memorials. And once the parties have served their concise statements, the court will then normally fix the first case management conference very shortly after that. And at that stage, the court will hear counsel and consider what is the best way forward. And the real idea is that there should be flexibility and that the choice, the decision to go either by way of memorials or by way of pleadings will depend on a whole range of circumstances. And certainly I would anticipate that one of the main issues at that first CMC will be which adjudication track to adopt. It is therefore really important at that first case management conference that the parties on both sides consider very carefully what they want in the litigation. They will have to consider what witnesses they wish to call, if any, what expert evidence they may wish to call, if any. They will have to consider the full timetable to the trial. And it's at the first case management conference that the judge will determine those matters. They'll have to consider as well a list of issues. And that is, again, it will set the track for the entire litigation from beginning to end so far as possible, punctuated, as usually is the case at the moment, by case management conferences to make sure that everything is on track. And so there will be, as I said, at that first case management conference, we anticipate a debate, perhaps a battle between the parties as to whether or not the case should proceed by way of pleadings or by way of memorials. So we thought we'd have a poll on this, at least at this stage. And if we could show the poll up on the screen, please. Here we are. So the question that we would like to ask you is, do you prefer pleadings or memorials? And I can see that some people have already started to vote, maybe many or everyone, I'm not sure. At the moment, there is a fair balance in favour of pleadings, but not much. Pleadings against memorials. But then I see there is a it depends answer of it's juggling around now. Pleadings are going up. Oh, it depends are going up. Pleadings are coming down a bit. Well, there we are. So bear that in mind. We thought that might help to, I can now introduce Nick Lingard from Freshfields, and he will perhaps try to persuade you to go rather one way or the other. Nick, not Mr. Landau. There we are. Nick, thank you.
Thank you, Judge, and hello, everybody. I'm pleased to see memorials have increased their position, though I am fascinated they have consistently remained the third between pleadings, memorials, and it depends. Pleadings well ahead at consistently over 40%, and it depends consistently in second position at over 30%. We can perhaps put the poll away, though we'll come back to refer to it as we proceed. As we proceed, I want to ask you to bear in mind this thought. Perhaps the preference for pleadings expressed in that poll by many of you reflects a reflexive result of your own area of practice. I want to suggest that those of us who practice principally in common law litigation have a natural inbuilt preference for pleadings, while those of us who practice principally in international commercial arbitration have a similarly reflexive preference for memorials. And I want to suggest that's been reflected in the poll, though of course only you all can tell me whether that's right. We'll also come back to look at why it might depend. Memorials having done not so well in that poll, let me start by trying to make somewhat objectively the case in favour of memorials. The first point to be made, I think, is this. Memorials require the claimant to make its case known in full and early on, not by way of bare, terse allegations, but supported by evidence. It flows from that foundational point that memorials should encourage settlement to the extent that the parties know the case presented and a respondent knows exactly the case it has to answer and thus can assess settlement early on. In a similar vein, I think the case for memorials goes that they should reduce the disclosure or discovery burden because each side is of its own accord presenting the evidence on which it relies together with its written submissions, with the result that discovery should be focused on what is missing rather than a broader search for material in the ordinary case. It might also flow from the election of memorials, the memorial track, that decision makers, judges or arbitrators as the case may be, are able to engage in the substance earlier on, which on that theory would mean they are able to make better interlocutory decisions, better informed by the case before them than may be the case if only there were bare pleadings. Having made the case for memorials, let me try to make the counter-argument again, trying to do so objectively for pleadings. The foundational point to be made is the obvious one. Pleadings are good at encouraging the rigorous joining of issues. So done properly, pleadings should enable the parties and decision makers to know where each party stands precisely on each individual issue, requiring a respondent to admit or deny each element of the claim against it. To do so without evidence in the first instance, but specifically to admit or deny each element of the claim against it. It should flow from that pleadings may well be better at helping to frame and limit the scope of evidence. That's especially true for expert evidence, so that expert evidence is adduced only on issues that truly are in dispute, not those that are agreed. And for example, in the context of a construction dispute, one can readily see how that might be helpful, where there is an enormous list of relatively discrete issues in play rather than a smaller set of big issues. I've made the point about expert evidence, arguably the same may well apply to fact evidence, in that rigorous joining of issues encouraging fact evidence to be limited to those issues truly in dispute, that truly make a difference. The final point to be made in favour of pleadings, it seems to me, is this. They should reduce the risk of submissions being ships that pass in the night because of that rigorous joining of issues, which may not be the case in rather fuller memorials, where there is, I suppose the case goes, a risk that one might fudge the position. Let me come briefly then to the "it depends" column in our poll. It depends. It may well be that you think it depends whether you are the claimant or the respondent, which you would prefer. And the typical case is, of course, that claimants prefer pleadings. They can get going sooner with a relatively lighter burden. No need to present their evidence up front, get the case off and running. And conversely, it is often the case that respondents prefer memorials, requiring the claimant to be put to the burden of evidencing its case from the outset, with the benefit for the respondent that it knows the case it has to answer. Again, I would suggest that those preferences, claimants wanting pleadings, respondents wanting memorials, are often more reflexive than the result of sustained reflection. And it seems to me, if I may, one benefit of this innovation in the SICC rules is the encouragement to parties to seriously reflect on which of the three tracks is the best for the particular case. I'm intrigued by the third track, with its genesis in the originating summons practice before the Singapore courts, the statement track, and of course we haven't discussed that in this dichotomy between pleadings and memorials. But to take us back to that statement track, I'll pass back to you if I may, Judge.
Well, thank you, Nick. The only extra thing I would say is, certainly as a result of what Nick has just said, is the importance of the case management conference. At that first case management conference, which will take place, I would imagine, say 6 weeks or so after the commencement of the litigation, after the parties, the claimants have served their concise statement of their claim and the defendant has served its concise statement, the court will then have an overview, and counsel will need to come to the court with a proper case management plan, advocating either one or the other. And under the new rules, the rules require the parties to liaise between each other to try to agree the best way forward. So when the matter comes before the court, the pros and cons of whether to have pleadings or memorials should have been aired already between the parties, and then you can come to the court, and the court will then consider the parties' views if they differ and have to decide. And that decision at that case management conference will necessarily dictate how the whole litigation process will then take place. So my I'm not sure, advice to all lawyers is to focus very carefully on that first case management conference. So with that brief introduction, I think I now pass to Justice Chua, I think, on the next part. Thank you.
Thank you, Justice Eder and Ms. Lingard. May we please invite Justice Chua Lee Ming, please.
Thank you, and good afternoon to everyone. What I will do is to cover the key changes under the new rules in two areas. The first area is evidence, and I heard instead of the current affidavit of evidence in chief, witnesses under the new rules will be by way of witness statements. I just want to point out that a statement must be which states that the maker of the witness statement believes that the facts stated in the statement are true. If the witness statement is not the statement of truth, the court may order the maker to verify the statement, or the court may refuse to admit the witness statement in evidence. And anyone who makes a false statement in a witness statement without an honest belief in its truth may face contempt proceedings. The second area that I will cover relates to discovery of documents. The basic premise remains the same. Each party must provide to all other parties all documents on which it relies. Also, the factors to be considered before making an order for production of documents remain largely the same as under the current rules. And these factors include unreasonable burden, procedural economy, proportionality, and fairness. But there are some changes that are worth noting. One, under the new rules, Disclosure is limited to documents in a party's possession or control. This provides a consistent test compared to the current rules in which you will find references to documents available to parties and references to documents in the possession, custody, or power of parties. 2. The test of relevance under the new rules is whether the documents are material to the issues in the case, or if there's an application for pre-action production of documents, whether documents are material to the issues in the intended proceedings. This formulation is used consistently in the new rules, compared to the current rules, which refer to documents that are relevant and material to the party's case or intended, and also refer to documents that are of sufficient relevance to the case or materiality to its outcome. In addition, under the new rules, documents that merely lead a party on a train of inquiry will not be treated as being sufficiently material to the issues in the case, unless the court determines otherwise. I expect that it will be an exceptional case before the court determines otherwise. 3. Under the new rules, again, as you have heard, the court has the ability to order general discovery in an appropriate case. The test of relevance is similar to that under the general discovery regime under the current rules of court, i.e., whether the documents could adversely affect the party's own case, or adversely affect another party's case, or support another party's case. The scope of documents to be disclosed in general discovery is subject to the auditing requirement that the documents are necessary either for disposing fairly of the cause or matter or for saving costs. 4. As Una has covered, the court may also make an order dispensing with the disclosure. 5. Under the current rules, to order production of documents is commercial confidentiality that the court deems to be compelling. The new rules clarify that this ground will not be to deny an order or production of documents. Issues of commercial or technical confidentiality can be managed through and conditions. This provides a better balance between the interest of protecting commercial or confidentiality on the one hand and ensuring fair trial on the other. So there you have it. See my screen lively. I hope you heard what I've said, and I will now go to Toby.
Thank you very much. Good afternoon and good morning to everyone. I'm going to cover 3 points as follows. Briefly, the significance of document production for both litigation and international arbitration. Secondly, the key parallels between the new SICC rules and prevailing practice in international arbitration. And thirdly, perhaps most significantly, the key differences between the SICC practice under the new rules and international arbitration, with a view to the potential impact of those differences on choice of forum and strategy. So firstly, the general significance of document production in litigation and arbitration. It's right to say, I think, that the document production as a component of litigation and arbitration is one of the major sources of costs, of procedural burden, of delay. And in recent years, we have seen generally a very vast increase in the number of documents that are requested and produced in both systems. Of course, electronic documents have brought us into a whole new universe of cost, delay, and procedural complexity. There remains throughout a stark contrast, however, between the scale of documents produced, the scale of this task, and on the other hand, the actual number of documents that in most cases matter, are relevant, or perhaps even dispositive. There is generally and has always been a monumental mismatch between the document production process and what actually matters and motivates the mind of the judge or arbitrator at the end of the day. This mismatch presents a challenge for both litigation and arbitration in terms of how to manage it, how best to balance all the competing interests. The interests, firstly, to have all relevant material before the court, the interest to maintain proportionality, fairness, a workable, cost-effective system, and also the danger of allowing document production to be used as a forensic weapon. In both litigation and arbitration, there's been therefore a move away from general discovery. And that sets up really a parallel, a very strong parallel between the new SICC approach and international arbitration. Both look at reliance production, that's documents that each party is relying upon, plus the scope for specific requests. And both see the importance of judge or arbitrator supervision. So just to focus a little bit more on the actual parallels, the basic structure remains the same in the sense that both systems are using, as I say, reliance disclosure plus specific requests. As Justice Chua has mentioned, the new SICC rules allow for resort back to general discovery in those cases where it's appropriate. In arbitration, that would also be conceivably possible, although rare, but it's within the general procedural flexibility of arbitration to allow it if the case demands. There are points of detailed difference between, for example, the IBA rules in international arbitration, which is really now a gold standard for document production, and the new SICC rules. These are points of detail that may not matter in the end. So, for example, the IBA rules focus on expressly a narrow and specific category of documents that can be requested. They also focus upon the tests of relevance and materiality, and they have a test of possession, custody, or control. In contrast, the SICC rules, the new rules, are not confined to narrow and specific categories of documents. They do not have a dual test of relevance and materiality. And they have a different test in terms of possession or control. They don't include custody. But actually, most of that won't matter in the end because the SICC rules in their new form contain many general principles which will be applied to ensure that document production is proportionate, that it is fair, and that it's appropriate for the needs of the case. That's set out in a number of areas of the rules. And I think in the end, it means that in terms of the bottom line, the two systems really are comparable. But there are key differences. And this is the third area I want to touch on, which is the most important one. These differences will feed in to choices on strategy and choices of forum. There are four main points that I'll focus on. Firstly, the task of identifying relevance and materiality. That is, when you actually make a request for documents, how does the court or how does the arbitration deal with it? Now, in arbitration, this has been problematic, and it's problematic for two reasons. The first is that when documents are requested, the stage of the arbitration at which that tends to happen is one where the tribunal has often not yet fully engaged on the merits. Actually, the most common process is to exchange what are called Redfern schedules after the famous arbitrator Alan Redfern. This is a simple schedule with columns which will tabulate the document request and the objections to that request by the opposing party. And there's then a spare column for tribunal comments. The common criticism, however, is that the Redfern schedule process, which happens in almost every arbitration now, causes a superficial review by the tribunal. It's an excuse for the tribunal not to roll up their sleeves and get into the detail of the case. And so the tribunal really resorts to a box-ticking exercise, looking at overall proportionality and balance on the basis of a limited review of the merits of the case. There have been attempts to deal with this, for example, by using early opening, sometimes called a Kaplan opening, which is to have the parties open the case very early on, perhaps months before the actual main hearing, in order to educate the tribunal properly on the needs of the case. The second point, which is relevant here, is that tribunals generally, as has already been mentioned by Justice Loh, they tend to suffer from a fear of prejudgment, prejudging the merits, and due process paranoia, which means that there is less discipline, actually, in terms of stopping extensive requests for documents. Tribunals will default generally to an expansive approach for fear that if they exclude a document, that might end up with a challenge, perhaps to set aside the award or to resist recognition and enforcement of the final award. On the other hand, the SICC does not suffer from this at all, because it has entrenched in its rules, as Justice Eder has commented on, has noted, a very important process of CMCs. Because of the importance of the case management conference in the SICC, the fact that lead counsel have to attend, the fact that it can happen at many stages and can be a very detailed, important hearing means that actually the SICC will get into the details much earlier on and will not have the risk of superficiality. Very quickly, secondly, pre-action document production. In the SICC, there is a specific rule allowing for production of documents before the commencement of the process, of the actual action. In arbitration, obviously, that is impossible. Thirdly, documents held by non-parties. Again, in the SICC, you can ask for disclosure of documents from non-parties to the process. In arbitration, that is impossible. And lastly, non-compliance. In arbitration, if documents are ordered to be produced but are not produced, there is a limited extent of remedies available. Generally, one defaults to the adverse inference, which is a blunt tool. And in the SICC, of course, all the powers are available of compulsion that are generally available to a court, including striking out, including powers of contempt, including adverse inferences, and many more. So there are greater options, actually, in the end, in the SICC than you would ever get in arbitration. Whether they are desirable or not depends on your strategic view as to whether you want to produce documents, obtain documents, or not. With that, I will hand back to Justice Chua to refer back to the handling of this evidence once at trial. Thank you.
Thank you, Toby. I just want to make two quick points from the practical perspective relating to trial bundles. You will find that the new rules will provide the guidelines that each bundle will be paginated and each bundle starts with page 1. This is important, especially when you, counsel, or the court needs to refer to the soft copies, because on the soft copy, the first page will always show as page 1. I have had cases where parties have paginated bundles in a running order so that volume 2 starts from where volume 1 ends. And then when I'm told page 2852, I cannot find that in the soft copy. It is very difficult. Second point I want to make relates to core bundles. Core bundles, as you know, can be very useful. A lot of thought has to be put into deciding on the documents to put in there. My practical point is sure that you have a cross-reference to each document in the core bundle to the source document, so that one can find the full source document whenever necessary to check on whatever one needs to check. And that's all I have. Thank you for listening to me.
Thank you, Justice Chua and Mr. Landau. May we please invite Mr. Cavinder Bull.
Good afternoon, everyone. I've been asked to comment on the new rules in respect of the provisions on expert evidence, which are in Order 14 of the new SICC rules. And the first and most important point to note is that the new rules provide that the court has to approve the use of expert evidence. Rule 2 sub 1 is short and to the point. It reads, no expert evidence may be used in court unless the court approves. This is quite a change. I mean, previously, parties together with their counsel, would decide what expert evidence will be adduced at trial. They will decide what they need to prove their case. That still remains the case, but an additional layer has been added on that the court has to approve, and necessarily that has to happen at an early stage in the process. The court has to approve what expert evidence will be led. The court will look at whether the expert evidence is relevant and also whether it's material. And the court will therefore be involved in this process of deciding what expert evidence should be adduced for this case at an early stage. And it's a very significant shift. Another way in which the court is now involved in the process at an early stage is in relation to lists of issues and agreed statements of fact. Rule 3 of the new rule says that parties must attempt to agree on a list of issues and also on a common set of agreed or assumed facts. Now, lists of issues agreed between the parties and agreed statements of fact, these are not new in themselves. However, what is new is that the list of issues and the agreed statements of fact must, under the new rules, must be approved by the court. Now, this necessarily, again, has to be done at an early stage, as the list of issues and the agreed statement of facts is needed before the experts can actually generate their expert reports. So we see here a picture being painted of the court being engaged at an early stage in deciding what would be useful expert evidence, and what those precise parameters of the evidence should be. This early engagement by the court will likely result in expert evidence being more focused, and it will save time and costs because the court is essentially giving its guidance to the parties and the experts early on so that when it comes to trial, things move smoothly and are focused. Now, the new rules also have various provisions stating what is needed in an expert report. It requires that the documents or materials relied on by an expert are specified in the report. The report also has to state which facts are known by the expert and which are being assumed by the expert. Importantly, the report also says that, or rather the rules say that the report needs to state that the expert owes a duty to the court and it overrides any obligation he owes to the party appointing him. Now, these various points I've just made are not new. They'll be familiar to all of those who work in and use commercial courts. The new rules do not ignore these and specify these clearly to guide parties. The rules also provide that the court can direct that experts meet and confer. There are also provisions saying that the court can decide the manner of examination of the expert witnesses. And this, of course, means that the court can decide whether traditional cross-examination is more appropriate or whether witness conferencing would be more effective. So we have in the new rules on expert evidence quite a good mix of innovation as well as established practice, reflected clearly in what are just 3 pages of rules. Now, one other comment I would make is that whilst the rules are concise, they have an impressive attention to detail. For example, Rule 6.3 says this. It says, a party is not deemed to have waived any right to submit that the party has no case to answer merely because the party's expert has testified in accordance with this rule before the party's non-expert witnesses have testified. It's quite an interesting provision. It means that the court can order witness conferencing at any stage in the proceedings, even at the end of the plaintiff's evidence, if that is convenient. And just because the defendant's expert has participated in the witness conferencing does not mean that the defendant has given up his right to make a submission of no case to answer and choose not to call his factual evidence. So the defendant retains that right, whilst the court retains the ability to hear expert evidence at the most convenient and efficient time during the trial process. To sum up, I think the most important point to take away from the new rules is the greater involvement of the court at an early stage in the process. That, I suspect, will have a very positive impact, both in terms of streamlining the process as well as increasing the quality of the expert evidence that is deployed. Those are my comments, and I hand the floor now to Cameron, who will give you his views. Cameron?
Thanks, Cavinder, and good afternoon, everyone. I'm speaking this afternoon on the user's perspective of the new rules, and I'll take the meaning of users to be the practitioners in the court and the parties they represent. And the approach I've taken is by considering how the rules deal with complaints that users have made about international dispute resolution, or IDR, to date. And we see those complaints reflected in various surveys by the Queen Mary University, and I'm thinking in particular of the 2018 survey on international commercial arbitration and the 2019 survey on international construction arbitration, as well as various articles and conferences and seminars where we hear complaints. I've noted 11 here. I'll list them now as an executive summary. I doubt I'll have time to go through them all. You'll be glad to hear. Some of them have been dealt with by others. But as the executive summary, the 11 complaints that I think the rules deal with well are time, cost, due process paranoia, party tactics, alternative dispute resolution, document disclosure, experts, summary disposition, non-responsive parties, third parties, and counsel ethics. Before going to those, and as a preliminary comment, I'd note the admirable brevity of the new rules. One has in mind that these rules are for an international audience, and an audience beyond common lawyers and beyond the common lawyers familiar with domestic common law court litigation. And so to appeal to that broader audience and to have that broader audience recommend to their clients that they include SICC in their dispute resolution clauses, the rules really do need to be to have that international audience in mind. And I thought, well, these new rules are a little bit like me, short and simple, but that's in this case, that's to be commended. Moving then to the first complaint that users have of other forms of IDR, and that is the time taken. The one theme that comes through very strongly reading through these rules is the degree of court control. And the concept is really reinforced that the litigation belongs to the court and not to the parties. And there's a rule there that specifies that the court has control over the conduct of all trials. That's the case anyway, I think, but it's reinforced in the rules and it reflects an underlying theme. Practitioners of arbitration, of course, they like to spout party autonomy, but it has its consequences. And the court here is, as it's stated in that first general principle, striving for an efficient and economical and expeditious disposal of the proceedings according to justice. So one would hope that a significant outcome of these new rules is that the time taken for resolution of disputes is reduced significantly. And we look forward to seeing how CMCs are run and how parties are kept to their schedules and to their promises. A corollary of that, of course, is that costs should be reduced. In addition to the matters that other speakers have mentioned, I noticed that at any time, the court can ask the parties for an estimate of costs or a budget. That's one of the ways that I think it's the ICC suggests keeping track of costs in international disputes. with tribunals asking for such things at an early stage and then keeping on to them as the dispute progresses. Due process paranoia, others have mentioned, I won't go into. Party tactics is one thing that came up in the 2019 construction arbitration survey. And of course, party tactics are interesting. It depends on which side of the fence you find yourself. If you're indulging in them, then you're exercising a legitimate right that's necessary for the prosecution of your action. If you're on the receiving end, then of course it's a dirty tactic. But the court's level of intervention in the SICC should reduce the perception of party tactics, with the court looking intently over the parties' shoulders. Another matter that came up in the construction arbitration survey was parties felt they would like the tribunal to be more proactive in suggesting or be involved in other forms of ADR. And it's interesting and I think helpful that that's picked up in these new rules. Often no party wants to be the first to suggest mediation, and in arbitration tribunals are loath to do so. So I think this is a positive thing for users, and one hopes that it'll be something that's taken up and exercised by the court. I won't dwell on disclosure or experts. Summary disposition is an important thing in the rules. We're used to it in litigation, but we don't have it in arbitration or to any great degree, and that is the facilities of default judgment, strikeout, summary judgment, judgment on admissions, and much later in the process, no case to answer. As a result of the court's control, there's much more control over non-responsive parties, with the ability to strike out claims or defences or take quite strong action against parties. And finally, quickly on ethics, it's not a complete answer to controlling the different ethics of the different nationalities of practitioners before the court, but the court is able to award costs personally against a practitioner, or in a serious case, hold them in contempt of court. So they're my comments on the user's perspective of the rules.
Right, thank you. Can you all hear me? All right, good. So thank you, all of you. That was a very, very interesting roundup. And I'm happy to say there are 18 questions. And I don't think we can get through 18 of them. So I'm going to pick up what I think are not only those with the most votes, but I think those that are the most interesting. So let me read out the top number of votes. Will or preference witness statement versus affidavits make any substantial difference, rate time, stroke cost, or parties, as lawyers will nevertheless treat the witness statements like an affidavit? That's the question. Bernard, would you like to start? I'll maybe pick you and one more to answer this. Can you give us some answer to that question?
Well, the witness statement will be made under a statement of truth, in a sense that the witness says that it is true. The reason, one of the reasons anyway, to go for witness statements rather than affidavits was simply to avoid, especially in international cases, the necessity to go before a formal notary or someone of that kind to formalise what the witness wants to say. Now that is an important matter in international work and will save time and will save money. But other than that, the witness statement will stand in a similar position to the affidavit. It will say that it is true, and when the witness comes along to give evidence, oral evidence, the witness will have to confirm under oath that it is true. So to that extent, the difference, there is not a great difference. And I think that's all I would say on it. That's all.
Toby, would you like to say something on that?
I don't really have very much to add to that. I apart from the savings which Bernard has mentioned, I don't think it will make much difference. It does raise the question as to what is the proper content of a witness statement and an affidavit, which is perhaps for another day. That's proven controversial in many systems because a lot of material tends to go in which is redundant or inappropriate, and which takes time to then deconstruct by cross-examination. So that is something which perhaps we will see the SICC developing a practice. I hope it will develop a practice in years to come.
Thank you. Maybe I just add one thing from my perspective. We had a case where counsel referred to the fact that the witness statement was sworn. He then started reading off parts of the affidavit and just said, "That's a lie, isn't it?" Then he read another part and he said, "That's a lie, isn't it?" After 5 minutes of that, one of the judges said, "Mr. So-and-so, I really find this most unhelpful. Will you please go to the heart of your case and ask your questions?" And I think that was a very salutary effect. If there wasn't that part that said these are sworn statements, the counsel wouldn't have gone that way. Right, let me go to the next question. It is anticipated that there will be a difference in the overall time and costs of the proceedings. No, is it anticipated that there will be a difference in the overall time and cost of proceedings between pleadings and the memorials track? Nick, would you like to answer that first? Yes.
I'll be happy to. It seems to me, yes, and it seems to me the answer is likely to be no, though the staging of those costs is likely to be quite different, which rather goes to my point about a plaintiff's typical preference for pleadings and a respondent's typical preference for memorials. It is probably true that a claimant or plaintiff is more likely to bear more cost earlier in the course of the proceedings if memorials are adopted. So the allocation of those costs over the life of the case, I think, will differ, with a claimant or plaintiff bearing more cost early on in a memorial track. But I suspect overall, in the balance for a case that goes through trial, there is not a big difference from a cost perspective. The final point I'd make is that timing difference, the staging of costs, is probably relevant to parties thinking about the use of litigation as a vehicle to achieve settlement, because again, costs will be staged differently as between those two tracks, though I don't think in the final analysis the totals are likely to be different.
Right, let me move to the next question. What factors will inform the party's choice of pleadings versus statements versus memorials? In what circumstances is one preferable to another? Cavinder, would you like to try giving us some of your views on that?
Sure, Judge. I think there are one of the things that will drive parties' choice is what Nicholas has mentioned just a moment ago. If they're thinking that settlement is something that's likely that will happen perhaps in the early stages of proceedings, then there may be an inclination to pick a pleadings platform because parties will not spend so much in terms of costs. Having said that, there are plaintiffs who would prefer, even if they're headed towards settlement, to be able to use a memorial system because their first shot would really deploy very quickly and very clearly, not just their arguments and causes of action, but also their evidence. And so hopefully incentivize the other side to come to the table. But if we think in terms of the trial and the ultimate destination, I think one of the critical things that counsel would think about is really what the judges would prefer. If I had to appear before a quorum of judges who were more familiar with the pleadings practice, then you might be inclined to go that way. And if you were appearing before judges who were a bit more familiar with the arbitration practice or the civil law system, then a memorial track may be more useful. So I think it's very much cutting the cloth according to what you need.
Right. Cameron, do you have any views on that?
No, sometimes it might be a matter of with the document you need to prepare the memorials. If your case depends on documents in the hands of others, particularly the opponent, then you might need to begin with pleadings and extract the documents from
them. Shall we then move on to another question?
Can I, Quentin, can I just add to this? I do think the distinction between memorials and pleadings at the beginning of the case is really going to be really, really important. The really important thing, I think, is that with memorials, witness statements are served sequentially. The defendant will not have to serve any witness statements at all under memorials until the plaintiff has set out its case and served its witness evidence. Whereas on pleadings, generally, I mean, the court can order otherwise, witness statements will be served simultaneously. And from a tactical point of view, therefore, it is my experience that, I'm not sure most, but many defendants generally like memorials because it forces the plaintiff to put out its whole case and witness evidence first. And then the defendant is in a much stronger position to respond. But I know there are different views, and other people in different cases may take a different view. But the decision whether to go one way or the other will be an important decision by the parties and indeed by the court.
Right, thank you. Lee Ming, you look very peaceful. I put this question your way. How would the court decide between the pleadings and memorials track if the parties are strongly divided on the appropriate track, especially if the merits are not clearly in favor of either one? Suppose you had that issue before you. How would you look at it?
Thank you, Quentin. This is probably the most difficult question to answer today. I'm going to go with what Cavinder said earlier. In the situation you pose, it seems quite evenly handed. I am common law trained. I'm going to do what I'm most comfortable with, and I'm going to opt for pleadings.
Right. Okay.
Can I? I'm being interrupting too much, Quentin. But my own view is similar to what has just been said. But my own view is it is the plaintiff's case, and my own view generally, if there is a big battle, that if the plaintiff wants either memorials or pleadings, then generally speaking, I would go with the plaintiff. It also deals with the point that it in fact potentially benefits the defendant, because the defendant will also, if it's memorials, will see what the plaintiff has set out, and if it's pleadings, so be it. So I would lean in favour of that, though there is no golden rule.
Right, thank you. I've got some questions that are things like, when will the rules be published? What is the average time for, maybe you can answer this. What's the average time for SICC proceedings from start to finish? I know we've had expedited cases which were finished very quickly, and some which we had to break up into tranches. Can you give us some stats on that?
So the current average time for SICC cases from either commencement or transfer all the way to the end, the conclusion of the matter, is about 16 months for writ action. So for cases which go by the pleadings track as it is currently, it takes about 16 months on average across all the cases that we've had.
Right. And on appeal, I know we had one appeal that was super fast when it was put on the expedited track. I believe it was something that, I don't have the statistics immediately here, but I believe it was something like one was heard on an expedited basis, 36 days between the filing of a notice of appeal and the release of the written judgment. I think that's quite a good result for anybody who wanted a speedy appeal and decision. Wouldn't you agree?
Yes, and
Bernard?
I think with got some OSs, which were dealt with also on an urgent basis, and that was dealt with from start to end in about a week. And those
Yes.
are where it's expedited. They came before the court on an urgent basis. We fixed a hearing very quickly and it was dealt with.
Right. So to answer that question, when will the rules be published? They are currently still being reviewed, I believe, by the authorities like the Attorney General's Chambers and the drafting section. We expect it to come out sometime later this year. I think that's the best estimate we can give. Yuna, is that right?
Yes, I think the expectation or the target is the later part of this year.
Okay. I think that's all we'll have time for. Thank you all for your questions. We will look into seeing if we can somehow answer some of these questions on our website, the interesting ones. But really, I'd like to say a very big thank you to all our wonderful speakers. You're all very experienced legal luminaries in the commercial dispute resolution world, and we really appreciate taking your time off and coming and giving us your insights. Thank you very much indeed. And I think with that, we can close this session so that we'll have a short break before the next. Right? Thank you.
Thank you.